All right, well, I've got two after, so why don't we go ahead and get rolling, because obviously we've got a lot of ground to cover here this morning. Good morning, everybody. I'm Mike Elmendorf, President and CEO of AGC New York State, joined by Brendan Manning, our Vice President for Education and Environment, and our esteemed panelists. We appreciate the three of you putting the time in and to put this together and be here with us this morning. Brendan will introduce you momentarily, so I will not repeat that. But I just want to offer some opening comments, and then I'll turn the program over to Brendan and our panel. Obviously there's been a lot of interest, a lot of questions about both the issues of COVID testing and particularly COVID vaccinations. On the second point, hopefully we are entering a period of time where the question of vaccination, at least in terms of availability and accessibility for the industry, will become a lot simpler. The president announced a couple weeks ago that he expected that by May 1st, there'd be enough supply for all adults to be able to be vaccinated, not as of that date, but for it to start, rolling forward. AGC wrote to the governor and the health commissioner earlier this month, urging that as he continues to phase availability or eligibility, as the case may be, for vaccination to different categories of New Yorkers, that construction should be included in that now. We think the time is right for that, both in terms of where things are with the virus and where things are with the vaccine. I'm going to throw up into the chat the link to that letter. If you did not see it, members should have gotten it. But clearly we're entering, we hope, a different phase of this situation that we've now been dealing with for a year. Hopefully we are seeing the light at the end of the tunnel, and that's where questions about both testing and vaccination are going to become particularly critical. So without further ado, I will turn things over to Brendan to start things off and introduce our panel. And again, thanks everyone for being here. Brendan.
Good morning. Thanks, Mike. I want to welcome everybody again here this morning and introduce our three panelists. Tony Adams is a partner with Adams LeClaire. Glenn Doherty is also a partner. He's a partner with Hodgkins Russ. And we have Kinsey O'Brien, who's a senior associate with Hodgkins Russ. I'll kick off the program first with Glenn, and we'll get going. Again, everyone should have a Q&A box. We do plan to get to questions at the very end of the presentation. So if you do want to hold off, it could be 40 minutes, 45 minutes to listen to our speakers. They may very well cover the question you may have. So if you do want to hold off, you can do that, and we will get to the questions at the very end of this as well. So with that, I'm going to pass control over to Glenn.
Brendan, thank you. To all, welcome to COVID-19 testing and vaccinations in construction, what contractors need to know or else. Definitely a topic that has been developing these past few months, and what we talk about here today will no doubt be refined over the next few days, weeks, or even months. So stay close to the AGC, because it's going to keep you current, with absolute certainty. How important is this topic? And Michael, started to kind of touch base on this. Look, it's incredibly important. Testing and vaccines is fast becoming the new normal, following a year of extreme dysfunction. Look, we as an industry, we worked this past year. A lot of us were fortunate to keep working and worked hard and strong, but we worked under very stringent reopening plans and various safety and health protocols. Still with all that in place, some of us took some COVID-19 outbreaks. Many of us, were fortunate or lucky and there were no outbreaks, and that was, fabulous. But we're now moving into the next stage, mandatory testing, mandatory vaccines. And, this is something that Michael started with a few minutes ago in the introduction. I've given a very, similar lecture to bar associations and other industry groups. And I've been giving it for, about, a month and change now. And I always begin my discussion about, vaccines, with the caveat that, hey, we're getting ahead of ourselves. here, because, vaccines aren't readily available. But wow, as you know, things have changed rapidly these past, few weeks. Vaccines, they're here and they're available. And, and it's what really makes, today's, program, extremely, extremely relevant. So, now what? Just looking, broadly at today's program, kind of give you a roadmap of, where we're going to go and how we're going to do this. We broke it up into two distinct sections. The first part looks at the law behind mandatory testing and mandatory vaccines. Looking at it, primarily and initially from the perspective of the employer. Can you test? Can you mandate vaccines? And what happens if someone, an employee refuses to test or refuses to vaccine? We have answers for you. And I think, we'll have the legal answers for you, on the Hodson side of things. And I think Tony's going to take into the practical world of how it applies to the construction industry. And kind of getting back to that, the second part of the program takes the legal background that Kinsey and I will lay out over the next 30 minutes and really applies it to your situation as contractors. So give me a second. I'm just having a little slowness on the page agenda. Okay, so when we talk about the right to test, we need to understand various laws. Americans with Disabilities Act, the ADA, National Labor Relations Act, NLRA, Health Insurance, Portability and Accountability Act, HIPAA, and the Occupational Safety and Health Act, or the OSHA Act. And we also need to pay attention to agency action by the U.S. Equal Employment Opportunity Commission, EEOC, the National Labor Relations Board, NLRB, the Centers for Disease Control and Prevention, CDC, and the Occupational Safety and Health Administration, which we lovingly refer to as OSHA. And finally, we need to think about wage and hour issues. Why? Because we always need to talk about wage and hour issues. It creeps its way into everything. Sorry, trying to get a page advance and it's not working. Thank you. If that was you, Brendan, thank you. Okay, the right to test. What's the law? The starting point here is the ADA. Know that the ADA generally prohibits medical examinations of employees unless they are job related and consistent with business necessity. This standard, according to the EEOC, according to the ADA, is met where the employer has a reasonable belief that the employee may pose a direct threat to the workplace due to a medical condition. Does COVID-19 present a direct threat to the workplace? Well, common sense says absolutely, and the EEOC agrees with that. So that's the starting place. It's a direct threat. It justifies testing. So given the ADA, given the language of the ADA, and given the guidance from the EEOC, an employer may administer COVID-19 testing to employees before initially permitting them to enter the workplace. And it can also do so periodically to determine if their presence in the workplace poses a direct threat to others. Just a best practice here in testing. Look, and it's a safe harbor issue. The ADA doesn't get in the way of employers when they're following CDC recommendations or other public health authorities, your New York State Department of Health, county departments of health, regarding whether to give a test, when, and for whom testing and screening is appropriate. Once again, that will give you the whole safe harbor aspect of testing. So you follow the CDC, you're not going to be charged with a foul under the ADA. So the next slide, please. Thank you. So what's the CDC? I told you, let's pay attention to the CDC. What's the CDC saying about testing? Look, an employer is good to test when it has the employee's informed consent, which requires disclosure, understanding, and free choice. And that means employees must receive the following information in advance of testing: the manufacturer name of the test, the type of the test, the purpose of the test, the reliability of the test, limitations of the test, who's paying for the test, how's the test going to be performed, how to understand the results that the test produces, what happens, what are the actions that flow from a negative or a positive result, who's going to receive the results, how the results can be used, and the consequences of declining to be tested. And then also, according to the CDC, when you have mandatory testing of employees, the employees need to also get a patient fact sheet, and that can be found on the CDC's website. If I can get the next slide, please. Thank you. Okay, let's talk about the National Labor Relations Act for a second, and we'll start with unionized employers first. Okay, absent a legal mandate, legal mandate being, an actual statutory or regulatory command that testing, must take place in a workplace or another affiliated area. Okay, absent a legal mandate, unionized employers must determine whether their collective bargaining agreements grant the right to unilaterally test their employees. Here, look at your management rights clause, of your collective bargaining agreement. A really well-drafted clause will give the express right to test. Some clauses will get close to it and give you some comfort in mandating a test. Most do not come close. So you need to take another approach when you have a unionized force. So when authority under a collective bargaining agreement and the management rights clause is lacking, know this: testing of employees is a mandatory subject of bargaining. And what that means is that you just cannot unilaterally command testing in the workplace without an agreement of the union or without at least bargaining to impasse. So you've got to involve the union if it's not crystal clear in the management rights clause. And actually, even if it is if you believe it's crystal clear in your management rights clause, it's not going to hurt to involve the union to own this decision, with you. But getting back to the collective bargaining agreement, most unions have been fine with testing. Some resisted initially, but know that every collective bargaining agreement is just a little different. Every management rights clause, just a little bit different, but if you need to, there are bargaining strategies to get you to the right to test. Okay, now let's take a sidestep. Non-union facilities, no collective bargaining agreement, non-union. Somewhat of a surprise here for probably some people that have been operating without a union for a long time. Look, National Labor Relations Act can still impact an employer's right to test its employees. And that's because Section 7 of the National Labor Relations Act grants employees the right to engage in concerted activities for the purpose of mutual aid and protection. And the examples of that, remember, concerted means more than one. So you got two people or acting on behalf of more than just yourself. Protesting against testing it could be an example. Communications among coworkers about testing could be an example. Flyers going around the workplace about testing, that could be another example. Coworker discussions at the water cooler or out in the parking lot about testing, that can also be can constitute concerted activities under Section 7. What does this mean in the non-union setting? Look, what it means is you can't, without violating the law, take any adverse action for employees that have engaging in concerted activities with respect to testing. It's not a bar to testing. It's just that you cannot take adverse action against those that have been acting in concert. So next slide, Brendan. Thank you. Test reliability. So we're talking about testing, and this is from the EEOC. Testing must be accurate and reliable. Antibody test, no good, not allowed. According to the EEOC, the antibody testing does not meet the ADA's job-related and consistent with business necessity standard for medical examinations or inquiries for current employees. Really, let me tell you, that's just a fancy way of saying that antibody tests don't determine if someone has an active case of COVID-19. It determines whether or not they have antibodies. It doesn't determine whether they have an active case of COVID-19. And for those that, that follow the medical news, look, there's repeat hits of, people are displaying and getting COVID, a second time, even after, exposure, to the virus the first time. They would in fact be testing both for the antibodies and COVID, but they don't both need to be there. What is good? What are the reliable tests from the EEOC? Viral tests, such as the PCR test, that meets the accurate and reliable standard. Just a kind of a follow-up here. The EEOC has been silent on the reliability of the rapid antigen test. Those are the ones that I know many of you have actually purchased and used in the work site. Those are the ones that the doc in the boxes use that you can send an employee to quick. EEOC has been quiet on them, but they will, if you ever got to the EEOC, they would say, we're not quite certain, but use the PCR test, if you can. Kind of a final note on the right to test. Look, the EEOC tracks the CDC's recommendations, and they could update and change the testing requirements in response to what the CDC says or recommends. So be on the lookout for additional recommendations from the CDC, and if that happens, obviously the AGC will keep you posted as well. Okay, protected health information. Both HIPAA and the Americans with Disabilities Act does regulate the collection, use, and disclosure of protected health information, often just called PHI. HIPAA generally prohibits a covered entity from disclosing PHI without an employee first executing a HIPAA compliant release or authorization. So what that means in terms of testing, employees must sign a HIPAA compliant authorization form, and such must be given to the testing laboratory. Best practice, because employers that have been doing testing, we've obviously been contracting with third parties. Best practice, look, review the vendor's security protocols for protected health information, and in particular, what the vendor is going to do in the event of some sort of security breach of this information. Look, if you're this involved in the agreement and you have the authority or the ability to put some additional clauses in it, look, put a provision in there into the third party agreement that's going to address and look at information security and the risk of a security breach. It should be in there, it's for your protection as well. Next slide, please. Okay, what is OSHA saying about testing? Well, early in this year, OSHA came out, issued guidance and said, employers, they can test. And if they do, just make sure you follow state and local guidance. That's good. So OSHA kind of did a sure testing is fine. And then, a little bit of a punt back, just follow what the authorities are saying. And that's fine, because that means OSHA is approving a testing mandate. Also from OSHA, they wanted everyone to know that COVID-19 is a recordable illness, and it's recordable when, one, obviously you have a confirmed COVID-19 case. that it is work related, that something, the person got COVID resulting from events or exposures occurring in the work environment or at work. And then finally, it involves one or more of the general recording criteria, which is, death, days away from work, medical treatment beyond first aid, loss of consciousness. If you meet all three, it is a recordable event, and OSHA is out there starting to look for these right now. Next slide, please. So I kind of alluded to earlier, our discussion just is never complete, without mention of at least one wage and hour issue. And here it is. Both the EEOC and the U.S. Department of Labor, and also the New York State Department of Labor, they've been silent on whether employers are required to pay employees for time spent undergoing COVID testing, travel, time at the site, travel back from the site back to work, absolute quiet. Is that work time? Is that payment time? Well, even though they've been silent, look, there is an old FLSA opinion letter regarding employer mandated drug tests. And that letter asserted that, look, time spent traveling to the test, as well as time spent undergoing the test and time spent coming back from the test, that's all hours worked for FLSA purposes, which means they're getting paid. So look, given that's where an old FLSA letter, look, common sense, it would apply with respect to mandatory COVID-19 testing. Once again, this is testing that we're making the employees go to. So next slide, please. Okay, what happens when an employee refuses to test? There are two and only two legitimate exceptions. And even though there are two legitimate exceptions, under federal and to a lesser extent state law, to be blunt, in the testing, it's really tough for an employee to assert these exceptions, as opposed to vaccines, where you have a far better legitimate chance to do this, which Lindsay will cover. So from the EEOC, employers, we can give, once again, we can give vaccines, but when we're required to offer an accommodation for an employee to take an exception from the vaccine, due to a disability or due to a sincerely held religious belief. Okay, once that triggers, okay, employers are duty bound to engage in what's called the interactive process. It's a meeting with the employee. What's going on? What's standing in your way of getting tested? Testing is good. It's right down the street. We'll bring you. You get paid for the time. What's going on? The employee is going to have to come forward and say, well, I'm disabled, so I can't get a Q-tip run around the base of my nose, or I have some sort of sincerely held religious belief. Like I said, testing, not the place to be really making these, but they exist, and it's possible. Look, in the interactive process, especially for the disability, it does present an opportunity to request medical information, confirming the disability and the need for whatever that accommodation, may be. Look, if it ever gets triggered in the testing, be it disability or religious beliefs, here's what potential accommodations could look like. You gotta make an exception here. Working from home. Okay, well, if you work from home, you have absolutely no contact, so I guess testing really isn't needed. Masking or double masking at the work site, well, that's enhanced protection, although we probably should be masking anyways under our reopening plan still. Switching an employee from a shift to where the employee would work with fewer people, well, that's less contact. Next slide, please. And just, if when we're going through the interactive process, understand that, an employee is not entitled to an accommodation of his or her choice. Employers have a say here too. Flat out, employers are not entitled to accommodate where it would create an undue hardship, which is really just, it's really, really hard, or it's really, really expensive. Here's an easy example. I will sit in the truck while someone else does my job. Negative. I mean, you're just paying for two at that point in time. That would get into the expense category. And notice this too. Even if you do fall into, the situation where it's just too expensive, I'm not going to do it, or it's just impossible, I'm not going to do it. That's because of what the employee is reacting. You'd still have a duty to kind of, take a look within and see if there's alternative accommodations that you could offer as an employer that, might cause the employee to go to testing with the accommodation. But all this said, like I said, it's tough in testing. If an employee simply refuses a COVID test for personal reasons, or their claimed reason for an exemption is disingenuous, or just, quite frankly, full of crap, look, that person can be removed from the workplace. There's discipline, removal from the workplace. There can be a suspension, and quite frankly, there can be a termination. We're not going to honor personal, exceptions. I'm not going to get tested because I don't want to. I'm not going to get tested because down the road I'm just so, I'm not going to take the vaccine anyway, so I'm not going to get tested. Negative. You can be suspended, you can be terminated, you can be sent home. So next slide, please. Okay, so this at this point in time, Kinsey is going to tell you everything you need to know about mandating vaccines. Kinsey?
Thanks, Glenn, and good morning, everyone. Thanks for joining us today. We're going to turn now to what I think are really some of the hottest and most fraught issues facing contractors and other employers. And that's really, can I mandate that my employees receive a COVID vaccine? If so, what are the limitations and risks attendant to that? What alternatives are out there to a mandatory vaccine, and how much do they really move the needle on my risk profile? And as Glenn said, even as recently as a couple weeks ago, we were really telling folks, look, this is premature. We're not there yet. The vaccine is not readily available. It's stringently limited to particular categories. And wow, have things changed dramatically in a matter of a couple weeks. So this is really particularly timely now. There are a number of issues that we should consider in connection with potentially mandating vaccines. The first is the fact that these vaccines are currently available under only an emergency use authorization, not full FDA approval. There are some OSHA Act and OSHA administration issues that we need to talk about, as well as positions taken by the EEOC, Governor Cuomo, as well as potential limitations under the NLRA. We have some important New York State legislative developments to touch on. We'll look at the potential alternative of a mandate in the form of a vaccine. As Glenn mentioned, we've always got to talk wage and hour, always there. And finally, we'll round out with a brief discussion on some workers' compensation and liability protection issues. So as I mentioned, the three currently available vaccines, the Pfizer, the Moderna, and the Johnson & Johnson, are currently approved under an EUA, which is really a mechanism that facilitates availability and use of vaccines during an emergency public health situation. This is not full FDA approval, which is typically a more time-consuming process. And under the EUA legislation, the FDA or other vaccine provider really has an obligation to inform the vaccine recipient of a number of things, including the risks and benefits of receiving the vaccine, the extent to which the risks and benefits remain unknown, whether there are any alternative products available, and really critically, that they have the option, the vaccine recipient has the option to say yes or no, to accept or refuse. So that legislation really does seem to prohibit, during the EUA stage, a mandatory vaccine. That being said, there's a solid read, we think, of the EUA that it's really directed at governmental entities and doesn't impact private employers. There is really a consensus in the legal community that we're going to discuss that employers, at least in the private sector and subject to a number of limitations and caveats, probably can mandate vaccination as a condition of employment, even at the EUA stage. But as with so many things over the last year, we are really looking at uncharted waters and a great deal of uncertainty. There is already pending legislation on the way the EUA affects the ability to mandate vaccines. There's a lawsuit filed in New Mexico that is really more targeted to public sector employers. It involves a county detention center employee who was mandated by a county order to receive the vaccine. And basically, when he refused, was told, shape up or ship out, and has filed litigation, the crux of which is, county employer, you can't make me serve as a human guinea pig. So a lot remains to be seen here, but the general consensus is, subject to some caveats, mandatory vaccinations probably okay in the private sector. What does OSHA say about this? So far, nothing. They have yet to take a public position on whether or not employers can require the COVID vaccine, but a prior position that they have taken is instructive. In 2009, OSHA issued a letter of interpretation indicating that employers could require the seasonal flu vaccine, subject to some limitations. First, the employee needs to be properly informed of the benefits of the vaccination. And I think most importantly, that employees who refuse the vaccine because they believe receiving it will create, what they reasonably believe that receiving that vaccine is going to create a real danger for them of serious illness or death. For example, a serious reaction to the vaccine, that refusing under those circumstances could constitute protected behavior for purposes of an OSHA whistleblower protection claim. Obviously, the key difference between this 2009 letter of interpretation and the current situation we're all in is that the flu vaccine was subject to full FDA authorization. So it remains unclear whether OSHA will fall in line with this same position under the EUA model where we currently are with the COVID vaccine. EEOC has taken a public position here. As Glenn mentioned, EEOC enforces, among other laws, the Americans with Disabilities Act. And there are really three different components to the ADA. The first is easy to understand, a non-discrimination rule, right? You can't treat disabled employees worse because of their disability. The other two portions are a little bit beyond that, or maybe a little bit more counterintuitive. The first is that you have to provide accommodations under some circumstances, which really goes beyond non-discrimination and says we need to be providing something extra, something different for disabled individuals. And the third component is that there are limits on an employer's ability to conduct medical examinations and make disability-related inquiries. And in connection with the vaccine, we're really going to focus on those two later components, accommodations and medical inquiries and exams. So EEOC's guidance came out at the tail end of last year. And EEOC, very interestingly, stopped short of saying employers can mandate vaccines, full stop. That doesn't appear anywhere on the text, on the face of the guidance. But really the guidance comes from the perspective of almost presupposing, of assuming that yes, employers can mandate the COVID vaccine subject to the obligation to provide accommodations under the ADA, as well as accommodations for sincerely held religious beliefs under Title VII, which is another federal non-discrimination act. So if an employee refuses to receive a COVID vaccine that the employer has mandated, it really becomes critical to explore with that employee why, and if there's a potential disability or religious issue there, to engage in the interactive process and explore whether accommodations may be necessary. It's incumbent on the employee to make that request for an accommodation, but it's important to note that an employer can't bury its head in the sand just because the employee doesn't affirmatively say, I am requesting an accommodation under the Americans with Disabilities Act. There are really no magic words here. Likewise, the employee doesn't have to say, I'm requesting a religious accommodation within the meaning of Title VII of the Civil Rights Act. What really the employee has to do is put the employer through a supervisor or an HR professional on notice that, there's some conflict between my disability or my sincerely held religious belief and your mandate that I receive a vaccine. And under those circumstances, the employer should be engaging in the interactive process. There may be an opportunity to request information, documentation from a provider about the disability and the need for an accommodation. There may be the opportunity to obtain some documentation or at least explanation of the sincerely held religious belief. And then you meet with the employee and you talk it through and figure out what accommodation might be appropriate. Potential examples could be an exception from the vaccine requirement, but we require them to use additional PPE that would prevent spread to other folks and provide them a greater level of protection. Or perhaps we're going to move them to a work site that doesn't require vaccination. We'll have them on leave or do a schedule modification. A lot of potential options there that may need to be considered. So the EEOC guidance does expressly contemplate that if an employer determines that having an unvaccinated employee, including one who's declined for disability or religious reasons, on site, that will pose a direct threat to the health and safety of others, and that can't be reduced, that direct threat can't be reduced or eliminated through accommodation, the employer can exclude the employee from the workplace. But the analysis really doesn't end there. The employer, once it does that, still needs to assess whether there are any other accommodations, such as remote work, which can be provided. Obviously, in the context of construction workers, that's not necessarily feasible. But I think it's important to note that once you get to the exclusion decision, you've still got to round out that analysis to make sure you fully thought through your obligation. So as I mentioned, there's another component here of the ADA, which is really the limitation on the ability to make disability-related inquiries or require medical exams. And the good news is the EEOC's guidance tells us that administration of the vaccine is not in and of itself a medical exam or a medical inquiry. It's a medical exam is a procedure to test if there are current impairments or health conditions, and a vaccine is designed to prevent you from getting an impairment or a condition. So it's not a medical examination. And it's also not a medical inquiry to require the vaccine or to even ask, have you received the vaccine? EEOC does clarify that the pre-screening questions for the vaccine, which do ask about health background and the like, those can constitute disability-related inquiries within the meaning of the ADA. And therefore, if the employer administers the vaccine itself or requires the employee to receive the vaccine through a third party with whom the employer has contracted, that those screening questions are going to need to meet that job-related and consistent with business necessity standard that Glenn talked about. That is not going to be required where the vaccine is offered on a voluntary basis or the individual is receiving it through a third party that is not contracted with the employer. So the upshot of what the EEOC is telling us is they are implying very strongly that vaccination can be a mandatory term and condition with some limitations. As Glenn suggested, I think that the disability accommodation in particular is going to be more of an issue here than it has been for testing. Certainly there are contraindications for certain medical conditions. So there may be legitimate bases here for folks to refuse. I saw a question come through on the chat, which I think is a really good one, which is, do political beliefs give you an exception here, right? Can I refuse based on my political belief? And you know, the straight answer to that is no. But of course, we're lawyers; we can't help ourselves. I'm going to caveat that there is, I think, a very fine line in the law between what constitutes a sincerely held religious belief as opposed to a purely political or philosophical belief. And in any situation where you're dealing with that, you really should take a careful look, fully kick the tires, and consult with your labor and employment counsel to figure out what side of that line the particular situation is likely to fall on. There are also some NLRA issues to consider in connection with mandating vaccines. As with testing, absent a legal mandate, such as a state statute that requires adults to receive the COVID vaccine, absent that kind of mandate, unionized employers are going to need to bargain over mandatory testing. It would be a subject of bargaining. Of course, every CBA is different. So, you know, perhaps we can look at the management rights clause or the waiver clause to see if there's any viable language that we can implement without bargaining. But, you know, that may be very difficult depending on your contract language. The even more important point, I think, is for even non-union employers. As with testing, there's that Section 7 that Glenn talked about. And that really gives the employees the right to engage in those concerted protected activities. So we're talking about 2 or more folks or someone acting on behalf of others. But particularly for mandating vaccines, I think there is a perception among employees, that is perhaps heavy-handed, that they feel as though it is an intrusion on personal liberties. This is a vaccine authorized through an EUA. There's a perception out there that it hasn't been fully vetted. And I think all of that leads to a higher likelihood that if you go down this mandatory road, you may see protests, you may see extensive water cooler or parking lot discussions about it. There may be some handing out of flyers and other protected concerted activities. Again, that's not a bar to implementing the mandatory vaccine, but it can create quite a contentious situation on the job site, and the employer's ability to take action to correct that contentious environment may be limited. Worth noting, Governor Cuomo has taken a position on this, a public position during a news conference on December 2nd, 2020. He said that you can't mandate somebody take the vaccine. We're trying to do it the other way, education, show it's safe. This is, you know, in our mind, not totally consistent, certainly with OSHA's prior position on mandatory flu vaccines. It's not really fully consistent with the EEOC position that came out just a few days later. We have found no evidence that Governor Cuomo has updated this position. Who knows what he's thinking now? But that is the position he has taken. As I mentioned, some important state legislative developments here. It appears Cuomo is also not up in making that public declaration on what his Democratic colleagues in the Assembly are doing, because Assemblymember Rosenthal out of Manhattan did introduce an Assembly bill that would, under certain circumstances, require New Yorkers to receive the COVID-19 vaccine. That mandate would apply to all individuals for whom clinical data has shown it's safe to receive the vaccine, and the mandate would be triggered if public health authorities Unclear which public health authorities determined that New York has failed to achieve sufficient herd immunity through voluntary receipt of the vaccine. There is an exception in there that individuals can avoid the mandate if they get a letter from a licensed medical provider indicating that they are medically exempt. It is unclear what the criteria would be for such a medical exemption. There is no Senate sponsor yet for this bill. It remains just, languishing in the assembly. We think it probably has a pretty difficult road ahead, but the open questions that it leaves and the general sense of, well, what happens if folks don't get this voluntarily, I think is emblematic of the types of issues that you folks as employers are going to be dealing with in the coming months. Another really critical state legislative development that is already effective. It was signed by Governor Cuomo on March 15th, went into effect immediately. So this is already impacting employers. This bill guarantees virtually every New York employee, whether employed in the public or the private sector, the ability to take paid leave to receive a COVID-19 vaccination. Specifically, the law says that employees can take leave for a sufficient period of time, not to exceed 4 hours per injection. This is not an automatic 4 hours, right? It is sufficient time up to 4 hours. So when an employee requests it, it would be appropriate and I think recommended for the employer to go have a discussion with that employee. Where are you getting the vaccine? How far do you have to drive? How much time do you think you need? And see if you can get the employee to admit to something that's less than the full 4 hours. I'm getting it at so I'm based in the Buffalo office, right, of Hodgson Russ. Let's say I'm getting it at the Buffalo location that's 10 minutes away from my work site, right? Under those circumstances, it may be hard for the employee to take the position that they need the full 4 hours. So those are the types of issues that the employer really should explore when it gets one of these requests. Note that the law does leave open the possibility that an employer could be entitled to more time if allowed through a CBA or the employer's policy. This leave time does need to be provided without charge or loss to any other leave bank to which the employee is entitled under an employer's policy, and that would include the new statewide paid sick leave law that took full effect at the beginning of the year. This leave is job protected, and by that we mean there are prohibitions against firing, threatening, penalizing, or really in any way retaliating against an employee because he or she has exercised their rights under the law. We are getting a number of questions on this law. I think there are some open questions. The bill is pretty bare bones. It doesn't give a lot of implementation related details. One critical one, can we get documentation, right? Can we insist on documentation that you have an appointment, that you actually received the vaccine? The law is silent on that. We haven't seen any guidance from the state. I would say that absent a prohibition, I would be reticent to read one into the legislation where it doesn't otherwise exist. Another open question, right? When I look at the text of the law, it seems to really provide a paid leave option for receiving the vaccine. To what extent is this time available for someone who is recovering from symptoms of the vaccine, I think remains to be seen. So suffice it to say, we think, at least in the private sector, employers can probably mandate vaccines. But again, there's a lot of uncertainty here. There's that New Mexico lawsuit. There's a lack of public, express public commentary from some of the key employment agencies. So some employers have considered incentives as an alternative approach, right? We're going to use the carrot instead of the stick. All good, right? No problems with that. Well, not so fast. EEOC has, for at least the last several years, maintain regulations and rules around so-called wellness programs that encourage employees to undertake preventative care that will, we think, benefit their health. And one of those kind of components of a wellness program has in the past been viewed to include flu vaccines and the like. So on January 7th, the EEOC issued a set of proposed rules kind of in that same vein that would have limited the value of incentives that employers could provide for collecting information related to the COVID vaccine. And really the upshot was you can only give items of minimum value, things like water bottles. What in the good world is a water bottle going to do for an employee who doesn't think this vaccine is safe and doesn't want it, right? So that was obviously of significant concern. Fast forward a couple weeks, the Biden administration withdraws these proposed regulations under a regulatory freeze, really leaving employers without any guidance on, can I do this? Can I use the carrot instead of the stick? On February 1st, 42 business groups joined together and said, give us something, right? Give us some clarity around whether we can offer incentives without running afoul of the ADA and the other laws that EEOC enforces. That request has so far gone unfulfilled. But some employers really are not waiting here. They are moving forward and implementing vaccine incentives, sometimes in a very public way. Some large employers, Aldi, Chobani, have announced hourly compensation to receive the vaccine. Obviously, that's mandated now in New York State. Kroger has offered a $100 cash bonus. Some employers are providing gas credits, travel expenses to allow folks to get to the vaccination site. The takeaways here, lawsuits remain possible. There's uncertainty about whether the EEOC is really going to get involved from the wellness activities perspective. And doing this as an incentive rather than a mandate really isn't going to get you out of the reasonable accommodations quagmire. The employer would still potentially be required to provide alternatives so that folks who cannot receive the vaccine because of disability or religious objections can still earn the incentive. And wage and hour, always there. It's possible that these cash bonuses could also be deemed non-discretionary bonuses under the FLSA, and therefore would require some retroactive adjustment of overtime for non-exempt employees. Other wage and hour issues, this is very similar to what Glenn covered with testing, right? To what extent is the time traveling to and spent at and traveling back from the vaccine site compensable? Based on that old FLSA opinion, I think the conservative approach is to assume where the vaccine is mandatory, that it is compensable time. You may think that's a moot point in New York now that we've got this paid leave law, but I would be cautious with that still. The paid leave law provides that 4-hour cap, and what if it takes 5 hours? What if they've got to drive all the way from Buffalo to Syracuse to get it? So definitely some issues there to remain attuned to. Finally, we'll touch on workers' comp and liability protections. Employers should keep in mind that injuries and illnesses arising from the vaccine, significant side effects and the like, could be compensable under comp. I think that's certainly likely to be the case where it is a mandatory vaccine, but also where it's encouraged, if there's a business benefit, if it's provided on site. I think it is possible under those circumstances that workers' comp could apply. And in fact, we are aware of at least one case out of Pennsylvania, our neighbor to the south, or it's south when you're in Buffalo, I guess, that when an employee had some pretty significant side effects from a flu vaccine, that was payable under comp. And there, it wasn't entirely clear on the facts of the case if the employer had made that vaccine mandatory, but it was clear that it was provided at the work site. And there, the court said granting workers' compensation benefits were appropriate. Finally, just keep in mind here, that there is a little something called the Public Readiness and Emergency Preparedness, or PrEP Act, at the federal level. And this act really allows the Secretary of Health and Human Services, HHS, to issue a declaration that would provide immunity from liability for claims caused by, arising out of, or relating to administration or use of countermeasures to disease. HHS has issued a PrEP Act declaration related to the COVID-19 vaccine, and has amended it a number of times, most recently to expand it to provide civil immunity to tort claims related to manufacture, distribution, administration, non-administration of the vaccine, including private distribution of the vaccine. So it is possible, to the extent an employer is mandating and providing these vaccines, that the PrEP Act may give us some cover. So with that, I will turn it over to Tony.
Thank you, Kinsey. Kinsey and Glenn talked about your rights as an employer to mandate vaccines. Hang on here. Brendan, are you keeping control of the slides? Here we go. Well, let me ask you to keep it, because I don't appear to have control of it. So go ahead, Glenn. Go ahead, Brendan. Rather than talk about your rights as an employer, I'm going to talk about what's the situation if the owner imposes a requirement on you, or you and your subs, to make sure you have either testing or vaccinations of employees before they come onto the work site. Can the owner require that of you? If so, if you're the prime, can you require it of the subcontractors? In either case, who bears the costs and delays, including those that are associated with labor issues? Go ahead, Brendan. I'm going to try, in the interest of time, just hit the highlights here, but obviously, hopefully we'll have some time for some questions. The first question is, how big a deal is what the owner is asking you to do? If there's a range, it can be just simply asking you to do symptom testing, which we've all been through. We've been to somebody in a hospital. It's not a big deal. You go through, you answer a few questions, someone takes your temperature. If that's the requirement, that's probably something you can deal with. Go ahead, next slide. The more difficult question, it could be a big deal. What if the owner is requiring you to test your employees and your subcontractors' employees before they come onto the site? Is that a big deal? Well, it is a big deal if your employees have to go to a healthcare provider or some local place to get tested, because that takes some time to get the appointment. It takes a couple of days to get the results back, and there's obviously quite a bit of delay built in there if you want the test. Furthermore, the test is only good for the moment that the test was taken. So if the owner's requirement is that you periodically or weekly or daily test your employees for COVID, then that is not a practical way to do it. Which then gets you the question of, well, do you have to set up your own testing site, your own testing clinic, if you want to call it, at the site itself? They call it antigen testing. It's available. It's possible to be done. It takes about 15 to 30 minutes per test. The cost, according to the CDC, runs from $5 to $50 per test. I'm guessing that the smaller sample size you have, the smaller number of employees, the higher you get on that cost realm there. But if you got a project where you've got to test not only your own employees, but those of all your subs, and it's a substantial project, you can be talking about a lot of people. And you can be talking about a lot of time. That's 15 to 30 minutes per employee tested. You can't test everybody all at once. So depending on the number of employees that have to be tested, if there's a testing requirement, you could be adding substantial time to your workday before you can actually get any work started. The CDC says at least weekly is for that kind of testing. What about vaccination? As Glenn and Kinsley have said, right now it's not that practical a requirement, but it's coming. Right now, if someone's required to be vaccinated, as we know, it's going to take 6 weeks probably before you have a result back. Very difficult to run a job that way. And recent studies have shown that there may be some reluctance in the construction worker community in particular to getting vaccinated. So that can be a big deal. Go ahead, next slide. So then the question becomes, All right, it's done. And the owner says he wants it. Let's go to the next one again, Brendan. What's the owner's incentive for doing this? I mean, these decisions in the work site are usually driven by liability concerns, as we all know. So first thing the owner has to consider is, am I liable if somebody gets sick on my work site? Well, there's a general safe place to work law in New York that applies to owners and contractors, but it does not specifically cover something like this. And it really can subject the owner to liability only if the owner either causes an infection on the work site, which is unlikely to happen, or if the owner becomes aware that his or her work site has become a source of COVID infection and doesn't do something about it. Both unlikely scenarios. That's assuming the owner is dealing with a building, a new building or a new wing, something like that does not involve interaction with the owner's own employees or the owner's folks who are using the owner's facility. However, if you go to the next slide, the owner may have an interest as an employer, and certainly contractors have interests as employers. Both have an obligation to make sure their employees have a safe work site in very general terms. OSHA has not adopted a standard concerning COVID. They have no specific requirements concerning COVID, but there is a general duty clause that requires a safe work site. So again, an owner now might have more concern if it's a renovation project or a project in which the owner's employees may be exposed to your employees or your subcontractor's employees. Now an owner may have more of a reason, more of an incentive to require some kind of testing or vaccinations before you're supposed to come on site. Next slide. OSHA has, in fact, let's go 2 slides ahead. OSHA has recently, just last week, issued an emphasis document saying that they're going to emphasize certain work sites in terms of inspections for COVID safety. Those include healthcare industries, residential care industries, but they also secondarily include construction industries. And based on a regional analysis, construction sites may or may not be prioritized for inspections for safety as to COVID. That doesn't mean you have to vaccinate or you have to test, but it means that your sites are more likely to be looked at for COVID as it being a risk, a health risk on your site. If you go to the next slide, this is really where things are headed. This tells us where things are headed. This is a CDC guidance that came out on St. Patrick's Day. And here basically it says testing is not required for a good health safety program, but it's a good idea. It could maybe incorporate it. But the more important thing it says is at the bottom, right now, vaccines are not a practical requirement for somebody's job safety or workplace safety code, but it's coming. And as vaccine supplies increases, and as the vaccines become more readily available, CDC guidance may, in fact, begin recommending that vaccinations be required as part of a workplace safety protocol. Next slide, please. So that's where we're headed. So let's talk about the owner-contractor issues. First of all, if the bid documents that you're bidding to tell you you're going to be subjected to mandatory testing or mandatory vaccination, then you're going to be, and you've bought it. That's a bid. If the possible exception we can talk about in public work, but in general, if the owner says this is one of my requirements if you want this job, and you buy into it and you sign a contract, then you're going to be stuck with it. And it's going to be your nickel, and you're unlikely to have time relief if it tends to be a problem. Now, if the contract documents don't specifically require it, and the owner comes along later after contract signing and says, hey, this is what I want. I want testing. I want a vaccination. Now use the contractor or the subcontractor may have some rights to additional compensation and to additional time, because the contractor, an owner cannot, after signing the contract, impose conditions on a contractor's work that unreasonably enlarges the cost of that work or makes it more expensive or more time-consuming to perform. Next slide, please. At the end of the day, it all depends on the contract. It's nice if the contract documents tell you up front, hey, we're going to require COVID testing, but they may not. They may be more generic than that. So if the owner says to you, I want you to start testing your employees, you got to look at your contract. Now, this is the consensus doc owner-contractor general clause, and it says this 2 things that are important. that most contracts should say. One, the contractor is responsible for their own means and methods. And two, the contractor is primarily responsible for making sure that qualified people are on the site, and that the contractor is responsible for on-site safety measures. And generally speaking, if it's a brand new project, the next slide, please, a greenfield site, a building unoccupied, the owner frankly has no real interest in job site safety, at least from a legal point of view. It's your responsibility as the contractor. It's not the owner's responsibility as an owner. This is continuing with this consensus docs general contract clause. This comes out and very specifically says the constructor holds a responsibility for safety programs. You need to look at your own prime contract with the owner because they don't all say this. This says that the contractor is responsible, and it also says that the contractor's safety program will comply with the requirements of authorities having jurisdiction. That generally means legal authorities. So if the local Department of Health comes along and imposes a requirement in the middle of your job, okay, everybody has to be tested now. Well, then that's something that your safety program is going to have to incorporate. And you're going to have a fight, frankly, with the owner as to whether the owner pays for that or not. You'd certainly be entitled to a time extension if the impact of that requirement affects your ability to complete on time. Whether the owner pays is another issue. Next slide, please. Again, the consensus doc 200 very specifically deals with if the owner wants to step in and impose safety requirements, after contracting, after the contract's been signed. And the consensus doc says is yes, the owner can do it, but only by interim directive, which in the parlance of that particular family of documents means it's going to be a directive that's going to be subject to additional time and additional compensation. It's like a construction change directive in the AIA documents. Something the owner is acknowledging is a potential change, and acknowledging that you may be entitled to time and additional compensation. Next slide, please. Now, in contrast, consensus docs also has a standard document construction contract for public work, and their prime contract is an older version. It does not have the caveat that the owner is going to have to do this by interim directive. It does not say the owner is going to necessarily pay something. But what it does say is if the owner gives a direction, and if it's reasonable, then the contractor is going to have to follow it. And that's going to give you far less rights in terms of looking for additional compensation or additional time, if it's in fact a reasonable request. And whether it's a reasonable request may turn on whether the owner has employees on the site who may be impacted by your employees. Next slide, please. When you're looking at your contract documents before you sign it, you sign your prime contract with the owner. What you got to do is look for phrases that may hook you inadvertently to whatever the owner may later require. A number of prime contracts I've seen say that the contractor will comply with any of the owner's facility rules or safety rules. And a lot of sophisticated employers do a lot of construction work, have standard rules. Hospitals come to mind. Some schools come to mind. And before you sign that contract, if you're concerned about this, you better ask for a copy of the current facility rules and see if they require testing, see if they require vaccination, or see if they reserve to the owner the right to require those things. If they do, then that's something you're buying into, and you are taking the risk that will happen. Under the current conditions, where vaccinations are still not readily available, especially to folks younger folks and people who are contractors, a requirement, even if the owner reserves the right to require vaccinations, it may not be it may not be a reasonable requirement, and it may not be reasonable just because it's just not readily available. To require vaccinations all of a sudden right now would definitely impact contractors' not only time for completing the work, but costs. And there is some precedent out there that says when an owner passes a rule that unreasonably limits the workforce availability to the contractor, that's something that the owner is likely to have to pay for. Next slide, please. Now, for public work, I mentioned, generally speaking, an owner can require whatever an owner wants before you sign the contract, as long as the owner lets you know that you're buying into it. There's an argument to be made that in public work, an owner, at least on a greenfield project or a project that's going to be vacant, unoccupied, there's a reasonable argument to be made that the owner has no legitimate interest, no legitimate right in dictating to the contractor what the safety program of that contractor is going to be. Under the public bidding laws, the owner is limited basically to fiscal issues. You got to take the lowest responsible bid. Your job as the owner is to get the best work at the lowest price without favoritism. So if there's a rule in the pre-bid statement or the invitation to bid that says, and by the way, you're going to have to use employees who've been vaccinated, that could be subject to challenge. Now, whether it's practical or not to bring that challenge is another question, but that's at least an issue out there. Next slide, please. Next two, go ahead again. Let's reach a scenario. We've got a scenario now in which the owner has legitimately directed the prime contractor to either vaccinate or test. Let's say test. That's the more likely scenario. Test all employees before they come onto the work site. Are the subcontractors going to be similarly bound? Well, that depends on the terms of the subcontract with the prime contractor. Here again, I took the consensus docs language from their standards form of subcontract agreement. And it says, to the extent that the terms of the prime contract agreement apply to the subcontractor work, then the subcontractor agrees that it's going to be responsible for all those same obligations under the prime contract agreement. This is a more or less standard flow down clause. We've seen them in all the different various standard forms that basically say the subcontractor is bound to all the prime contract documents. If this is all you've got, if you're the prime contractor and this is all you've got, it's questionable whether you can flow down that workforce requirement, that vaccination requirement or testing requirement. New York courts have been tended to limit the stretch of these kind of flow down clauses and limit them to situations that affect the subcontractor's work in particular. Next slide, please. However, the subcontracts will also typically have safety requirements. And again, you got to look, if you're whether you're the sub or the prime, you got to look at your subcontract safety requirements. The consensus stock requirement, this one is particularly favorable to the prime contractor. It says the subcontractor should comply with all applicable rules. So if the prime has bought into the owner's rules through its contract, then certainly the subcontractor has as well. Furthermore, there's an argument that even owner-imposed rules that come after contract signing are applicable rules. Under this language, a subcontractor may have less to quarrel about in terms of cost or time impact than the prime contractor does. As you can see, the subcontractor is required to establish a safety program that conforms to whatever requirements not only are in the current safety programs of the contractor and the owner, but any requirements recommended by the contractor or the owner. So under this version of contract, and probably many others as well, the subcontractor has less ability to resist or shed the cost of this kind of a requirement that comes along whether before the job is signed or after the job is started. Next slide, please. This is the AIA standard subcontract form, the A401. It's equally unfriendly to the subcontractor. It says subcontractor shall comply with safety measures initiated by the contractor, period. So if the contractor initiates testing because the owner has told it to, under this language, the subcontractor is going to be responsible for it as well. And there are arguments to be made. As Kinsey says, we're lawyers here. Our job is to make arguments, and arguments can be made even with this kind of language that a subcontractor may be entitled certainly to additional time, maybe even to additional compensation. But this kind of language makes it tough on the subcontractor. Next slide, please, Brendan. When you're dealing with this issue, prime contractors, subcontractors, don't forget that purchase orders may involve these issues as well. Some POs require people to come onto the site to make deliveries, to set up equipment, to inspect equipment, or to inspect construction, commissioning after the equipment's been installed. The typical purchase order does not reserve the right of a contractor or sub to impose work site requirements on these folks. So you need to be very careful as a person ordering materials from a purchase order. If you want to make sure you reserve your right to pass on these requirements to your vendors, you got to put something in your purchase order for that. Next slide, please. Go ahead again, Brendan. Labor issues. Brendan and Glenn talked about some of this. This comes up either if you're a union signatory company or if you've got a project with a project labor agreement. A lot of, if you're not familiar with it, a project labor agreement imposes the local union requirement contracts on everybody who puts people on the job. So even if you're not a union signatory, these issues can impact you. Next slide, please. There's two basic issues I think that I've identified. The first is the consent of the union required? Glenn and Kinsey talked about this. Depends on your management rights clause. This is one from a local, this is one from the laborers agreement in the Buffalo area. And this one is broad enough that it certainly would permit the contractor to impose testing requirements or vaccination requirements on the people coming onto the job. But other union rights clauses are not this broad. It's going to depend, regardless of what your union rights clause says. And I think this was Glenn's advice. Work with the union anyway. You don't want problems. It's something they're not likely to give you a hard time on, especially if it's a workplace imposed project and not something that you're trying to do with your employees generally. Next slide. This is the more likely issue, hiring hall issues. And I say this is more likely because this is something that we all saw just with COVID in general in the last year. There were union halls that could not get people to come out to work at sites because the employees were allegedly afraid of contracting COVID, and B, there was a very generous unemployment benefit available. I was a consultant on two projects in particular where electrical contractors could not get anybody to come out of the electricians union to work a job site, because allegedly they were afraid of COVID infection. You may encounter that same kind of a situation with a testing requirement or with a vaccination requirement. In the union context, PLA or collective bargaining agreement, there may be hiring hall responsive requirements. They run the gamut from the employer can call the hiring hall if it wants to, but can bring its own people on board as long as they're union people, to you have to get your people out of the hiring hall. For PLAs, it still tends to be the latter. You have to get at least some of your people out of the hiring hall. Well, if the people out of the hiring hall say, well, I'm not going to take a test, and you go back to the union, well, this person rejected it, send me someone else, that's going to take some time. It may either the amount of time you need in order to put together a workforce that's willing to be tested, or it may reduce the size of the workforce you're able to put on the job. And this may apply with you, not only to you as a GC, but also to any subcontractor. If this scenario happens and the union won't provide people or can't provide people that are willing to be tested or willing to be vaccinated, then your practical options are find your own hires if the union will let you. You're still going to have to make them sign up with the union. You're going to have to underman the job and seek a time extension from the owner. You're almost certainly won't get additional compensation from the owner because you're unable to put together a sufficient crew size. Several contracts say that labor shortages are a basis for a time extension, but some don't. And then if that labor shortage is just a labor shortage that you are having because of your local union and not one that others are having, then you may not even get a time extension for that. You can't just turn around and subcontract this work to somebody else, because as a union contractor, you're typically obligated to subcontract only to other union contractors, at least for the scope of work that you're talking about. So ultimately, you may be stuck with the only option of going back to the owner and saying, I can't get the people, I can't get through the union on this. You're going to have to take this out of my contract and let someone else do it. And that may be the only practical solution. Next slide, please. Other issues that might be affected here are, you may not be able to get the number of apprentices you want. You may have to work at a less than optional apprentice ratio on a prevailing rate job. So you may be more expensive than you had hoped because you're not going to be able to get a complement of apprentices. A year and a half ago, the legislature amended the labor law to require workforce diversity requirements on everybody who does public work. No one seems to be enforcing this yet, but the law basically sets, call it goals, rather than quotas, but goals for percentage of minority and women employees on every crew, under every trade. Now, if that begins to get enforced, the ability to comply with that may well be affected by this problem of trying to get people who are willing to be tested or who have been vaccinated. The other big issue is that if you're conducting a testing program on site, you got to be very, very careful to keep everybody separated from one another prior to the test every morning or every week. Because the worst thing you could probably have someone come through and test positively after just hanging around with everybody by their truck having coffee. Now they've all been exposed. Now you've got a real problem with whether you can use any of those folks. I guess in conclusion, what I would say is this. This is coming. The requirement of job site testing, it may not be coming, but the requirement of job site vaccinations is probably coming. Once there's sufficient supply out there, anybody who's got any owner who's got people nearby, whether it's a school project, whether it's a hospital project, is going to want to see only vaccinated people on the site. So maybe if I could give you advice now, it would be, contact your labor council and start setting up a vaccination protocol now, so that when these requirements do come down the pike, you'll be ready for them. Thanks, Brendan. This slide obviously is some additional cautions that you need to think about. As it says, it's rapidly moving target. You need to stay up to date. Staying up to date, by the way, is especially important in industries or sites like schools. The education department has a whole series of safety regulations that apply to contractors when they're working on school grounds. They don't presently say anything about COVID testing or COVID compliance, but they may be changed to do that. The state industrial code that everybody's bound to doesn't have anything right now about COVID testing, but it could happen. So you're going to have to keep an eye on the regulations that apply to the industries you're working in. I guess you can see the rest of it yourself. And at this point, I think we can just open up to questions.
Sorry, didn't realize muted. Thank you, Tony. Thank you, Glenn and Kinsey. We do have a few questions that have come through. A few people have put a few things in the chat, which I think we've gotten back to on some of the questions. But in the Q&A box, first question I have here is, many women seem to be concerned about potential fertility and birth issues that could result from being vaccinated. They seem to not be against taking the vaccine eventually, but wish to wait 12 months to see if there are any issues that arise since the vaccine has not been FDA approved. Any thoughts on this?
Yeah, I can take this one since vaccines were in my bailiwick today. My initial reaction to that is, if it's a woman who is currently pregnant, I think that there is probably a decent likelihood that could be construed as an accommodation request, right? So if you're mandating vaccines, that perhaps that is an ADA issue. If it's a woman who is not currently pregnant, is considering becoming pregnant, I think that there's a decent argument out there that is not the case, right? Because she doesn't have any medical condition. But this is, I think, one of the many open issues, particularly given that we're under the EUA framework. So it would really depend on the specifics and also any kind of medical documentation that the woman is bringing to bear. Suffice it to say, it's possible that an exemption might be necessary under those circumstances.
I would agree, Kinsey, but I don't know what the accommodation would possibly humanly be, on for the pregnant employee, searching for an accommodation, especially in construction. It's a tough one because you're in or you're out. I think on office clerical administrative work, the employee would have a far better shot at requesting and achieving an accommodation as opposed to field labor. That's gonna be a tough one.
Yeah, I agree.
agree.
Distinction of female, I might want to get pregnant versus I'm pregnant and I'm showing. I agree.
Yeah.
Okay. The next question, I guess, is more of a statement. Well, the actual accuracy of the flu vaccine being below 50%, CDC is basically guessing. How can an employee legally be mandated to take a vaccine that they have no idea what the long-term effects are?
Yeah, I think this comment hits on exactly what's at issue in that New Mexico lawsuit. This is an EUA. This is not full approval. We don't yet have all the data on long-term impacts. So those are kind of the issues that we're all contending with in real time. But I do think that there remains a good argument, despite that lack of clarity at this point, that it is, at least in the private sector, within the employer's authority to mandate.
Okay. Next question is, how many times can an employee be tested? Employees will be on many job sites and the test results are not always timely.
The test itself would be, you know, unlimited. You know, the issues to flow would be, you know, wage and hour pay. But you know, if an employee goes from site to site to site, and each facility has a testing requirement, then they're going to be tested within that protocol and either going to hit. So there is no cap on, you know, testing. There might be a cap on whether they're being compensated, but, you know, testing is testing is testing.
Okay.
Yeah, CDC recommends at least weekly if it's going to be useful.
Yeah, Tony, the neat issue though is when a worker is coming in and out of the hall or from job site to job site, you know, they might hit, you know, 6 days of consecutive testing, and you know, there's nothing you can do. I mean, the CDC says, you know, you're in a good place if you're doing this weekly, and I agree, and I think everyone agrees. But you know, when you're going to a new site who has, you know, there are rules. I mean, you know, many sites, for example, are starting to have testing requirements of, you know, any new, you know, employee to the site, you know, is going to prove he or she is, you know, is in good form for the test. So, you know, the more movement, quite frankly, I think it's going to result in more testing.
Okay, the next question is, so if I'm not allowed to ask for a copy of the vaccination or proof that they'll be vaccinated, then how can I ask questions about where they take it, or why do they not want to take it?
Yeah, so there is nothing in the state legislation that I think that this is really asking about that outright prohibits asking for proof that you have an appointment and that you ultimately did receive the vaccine. I'm not presently inclined to read a prohibition into a statute where it doesn't otherwise exist. And in fact, EEOC has taken the position that from the ADA perspective, asking, you know, when are you getting vaccinated? Where are you getting vaccinated? Did you get vaccinated? Those are not disability related inquiries. So I think you can make those inquiries. The more difficult one is when someone is asking, is saying, I don't want to take it. The why, that really is a disability, or could be a disability related inquiry, because there may be medical reasons why the person doesn't want to take it. But in that case, if it's a mandatory vaccination requirement, what that person's really seeking is an exemption from the requirement, the accommodation. And I do think it's appropriate when someone's made an accommodation to be asking, okay, well, why?
And I think it's also appropriate, and you know, you know, Kinsey and Tony, feel free to disagree with me or tell me I'm wrong. You know, getting back to the initial question, you know, you are going to be, you know, the statute doesn't prohibit you from securing some sort of documentation in support of the 4 hours pay for the vaccine. So, you know, if I see nothing wrong with an employer saying, okay, look, you got it, good for you. I'm taking you for 4 hours. Let me see that little crazy card they give you. You know, fine, done. I mean, there's no prohibition against that. And quite frankly, that's the ultimate proof that you should be entitled to, you know, 1, 2, 3, or 4 hours.
Agree.
Okay, the next question was, do you recommend a vaccine policy be established by the employer?
My thought on this, and Glenn and Tony, let me know if you disagree. If you're going to mandate it, I think it would be a good idea to have that set forth in a written policy that's uniformly applied. If you're not going to mandate, you know, maybe you don't need to go down that road.
I agree. I would say this, it depends what kind of industries if you're doing a lot of hospital work, if you're doing a lot of schools work, I think you should anticipate these kind of requirements coming down the pike. And so you might want to have a policy, and you might want to actually think about a program where your people have to get vaccinated to be eligible to work on those kind of projects.
Okay. The next question, someone specifically typed to Kinsey, but it says, does the PrEP Act protect employers from workers' comp claims stemming from bad side effects of a vaccine that the employer encouraged and offered to employees at the work site? I thought I saw in the last slide that the workers' comp benefits have to be exhausted before PrEP would kick in?
Yeah, so I think that you did read the slide correctly. My sense, and I don't know that we have crystal clarity on this, but my sense is that PrEP is not going to prevent workers' comp liability, right? Workers' comp is, yes, we look at whether it's a work-related injury, but it's kind of intended to be somewhat along the lines of a no fault. We're just providing these benefits. So it's not really, in my mind, something that requires a civil immunity that the PrEP declaration is intended to cover. I think that the upshot is that, yes, there's probably going to be comp liability. And then to the extent we've got really severe side effects, severe reaction, there's this fund that would kind of fill the hole if there's excess.
Okay. Next question is, are you able to ask employees coming back to work if they had previously tested positive for COVID?
Well, that's in the standard questionnaire from CDC, EEOC. So absolutely. In fact, that should be your, that should be in your 4-question, daily questionnaire anyways.
Okay, the next one could be wide open here. Are there any recommendations regarding illness and injury record keeping for future lawsuits?
Well, it's you start with the OSHA requirement that that it's recordable. If the 3 factors are hit, you got COVID, it happened at work, and there was loss of time or death or an unconscious. So you have a record keeping there. I mean, quite frankly, I mean, just in terms of your employer or your job site policies. I mean, I generally have document retention. Advice and counsel which go out to folks. And I think for accidents, I would keep, all job records in that for at least 3 years, and probably I'd tack on a year just for safekeeping.
I would add that the difficult question there is, did it happen at work? Someone claiming that they contracted COVID at the work site, construction work site in particular, is probably a pretty tough sell. And how you protect yourself from that, I guess the only way as an employer you can protect yourself from that is have some kind of testing or at least screening program, so that you can show that on the day that person claimed they contracted COVID at your site, A, there was no complaint made, and B, you had this policy in place that made it unlikely that the person contracted it at your work site.
Yeah, Tony, that's great. That's smart. I mean, it gets back to your internal questionnaire and maybe even a scope to the forehead by way of a temperature read. I mean, it's great. I mean, I think it would, that would go a long way to, protect. And by the way, it just gives you a safer workplace anyways. But beyond that, it is a liability protection.
Next question is, when the long-term efficacy of these vaccines is not known, even medical professionals do not seem to know if we need to get revaccinated each year. Can employees and unions use this argument against mandatory vaccination as blanket protection?
Well, I mean, look, once the vaccine's over, you're still going to always, run into, whether or not it's a mandatory term and condition, of employment, and whether or not you have rights under your management rights clause. And you have the right, which Tony pointed out in his sample clause, you have the right to test, you have the right to vaccinate, and it's just going to be the case, or if you don't, you're going to have to engage the union, in negotiations and either get an agreement or bring it to impasse. Either way, an impasse, you make your last proposal. So I don't see it as a stall. I see it as maybe, we're going to be exactly where we are today in 9 months from now, having to do the same thing over again, where we're going to have to kind of dust off today's lecture to realize what we need to talk to the unions about.
There's also a difference between whether you as the employer are proposing to require vaccinations of all your employees, or whether you're bidding a job that has that vaccination as a requirement. If it's the latter, the union don't want to lose that work. You go to the business agent and they say, look, here's this job, here's this requirement. Can you accommodate me or not? And you're much more likely to be accommodated in that scenario than if you're trying to impose a rule on all the people that send to all your jobs.
Yeah, Tony, you probably have detected, Tony and Kinsey, kind of a changing philosophy. It's coming from the halls these last, many months, because, I've fought with a lot of unions over 30 years, but this is something, one of the very few things that everyone seemed to have real global, engagement on, and a lot of quick agreement. I mean, unions they didn't fight us on safety protocols. In fact, they were championing safety protocols. They were asking for supplemental agreements on safety and health. And we were all on the same page. So I really, Tony, maybe in Western New York you found it, but I found people around, the unions to be quite on board with everything we were trying to accomplish, because it went to employee safety, member safety.
I just a couple more questions. One actually came up in the chat rather than the question box, but it just says, are you allowed to take a request from employees at this point to see who would want to take the vaccination and who would not, or just a survey, I guess?
I don't see a prohibition. There's no prohibition in any of the statutes. I mean, and if you have the authority to mandate vaccines, you can certainly ask who the hell would want one if I mandated it. So, yeah.
Yeah, I totally agree.
Okay. And our last question that came from the question box: does the employee have the right to pick the vaccine supplier? Moderna and Pfizer are relatively new and experimental mRNA technology, where Johnson & Johnson shot uses established vaccine technology.
Well, if the employee was given that right, I think there's 300 million people who would also like to figure out how to do that too, because, for those of us that have been fortunate enough to get vaccinated, it's you go what they're given. It's like trick or treating in a neighborhood. You can't complain about the Milky Way bar when you want it. It is what it is. And take what you got or get out of line.
Excellent. Okay, well, that's it. We've gone through all the questions that I've seen here between chat and the questions box. Again, I appreciate everybody's time. Glenn, Kinsey, and Tony, great presentation. We appreciate this. And again, I want to remind everybody that is still on. We are recording the program itself, and the PowerPoint, a PDF version of the PowerPoint, will be posted. We can email blast it out to everybody who signed up, as well as posting it to the coronavirus area on the AGC website. So you can actually find it there as well for anybody that did happen to miss it. So again, thank you for your time. We appreciate it. And everybody be safe. Thank you.
Bye.